All right. Good afternoon, everyone. It is June 12th, 2018, 1 p.m., and this is the noticed public meeting for the Child Support Guidelines Committee. And we will start with me taking roll call. Kathleen Baker.
Present.
Karen Cliff.
Present.
Present. Ellen Crecilius.
Present.
Senator Farley. Assemblyman Fumo. Judge Hoskin.
Here.
Nova Murray.
David Castagnola for Nova Murray.
Assemblyman Pickard.
Here.
Judge Robb.
Present.
Senator Roberson. Joseph Sanford.
Present.
Judge Shirley. Justice Stiglitz.
Here.
Kim Surratt, present, and Don Throne.
Here.
All right, we have a quorum. We will now move on to the second agenda item, which is public comment. Public comment will be restricted to 3 minutes per person. I am rude and cut you off, but we keep a very tight 3 minutes. So do we have anybody in Las Vegas that would like to give public comment at this time? Okay, seeing nobody approach the table.
Yes, we do.
Okay, I wasn't sure. If you'd like to give public comment, come on up to the table. When you approach the table, there is a button there for the microphone. It says MIC. You can push that so that we can hear you. Please give us your name first and spell it if it's a difficult last name. And I will begin your time for 3 minutes.
So am I on right now?
Yes,
Okay.
we can hear you.
Greetings, legislative. Here, my name is Mr. Ron Easley. I'm here because I'm actually a custodial parent. And I have a couple of issues I needed to address. First of all, I believe that the minimum amount of child support should certainly be increased. It should be increased from $150 to $200 per month. And my reasoning for this is because of this here. The cost of goods and services have dramatically increased since the original Chapter 125 of the Nevada Revised Statutes was in fact enacted by the legislator. In addition to that, sir, the cost for access to products and services that in fact generate income has dramatically decreased. A case in point, if I bought an HV Vixia 30 camcorder, high definition camcorder 10 years ago, which I bought for $1,000, today the cost for an upgrade to that equipment, a complete replacement, is only $215, $1 or $2 worth of change. So as you can see, the cost of various products to generate income has in fact increased. Not only that, it's the digital age. This means there's opportunity for non-custodial parents to generate income immediately with respect to online programming, Google Ads services, and so forth and so on. An opportunity to generate income today has vastly increased over 10 years. Those opportunities did not exist 10 years ago. And furthermore, one last point, if you eliminate the minimum child support in black and white plain English for every plain person to read and see, such as it currently is right now, people will get confused. More children will in fact be abandoned. People of plain, without a college degree, they need to see it in black and white English. What is the minimum child support? They need to see something plain and clear. We have a PhD person who wrote this report. They don't speak to people without a college education. I happen to have a college education, but I'm sympathetic to those people who do not have one. They cannot understand something that's vague and ambiguous. We need to put it in plain and clear English, the minimum child support written in dollars with respect to the digital age today. It's very simple. It's not complicated. It really isn't. If you eliminate that, there will be more children abandoned. I will guarantee it. The opportunity is there for people who want to make money. There's no excuse to be so-called broke unless you're basically incarcerated. I get that part. If you're not incarcerated, you have no reason to be flat out broke. You're broke because that's what you choose to do.
Okay, thank you very much.
Wait a minute, one more point.
It's okay. You've got 30 seconds.
Okay, one more point. You need to remain, the hearing masters need to be subject to the NRS statutes, not an administrative code. This needs to stay in the NRS statutes because unfortunately you got some corrupt hearing masters who have second agendas they need to be held accountable such that their conduct can be complained to the Nevada State Bar if necessary. That's all I have to say.
Okay, thank you very much, sir. Does anybody on the commission have any questions for him? We can call him back up if you do. Okay. Thank you. Is there anybody else in Las Vegas that would like to give public comment? Hearing none?
We have none.
Oh, okay. See, I can't see everything, so thank you. Okay, whoever else is in Las Vegas in person, please just approach the table.
I'm sorry, we don't have any more.
Oh, okay. Thank you. Is there anybody on the telephone that would like to give public comment? Hearing none, is there anybody in Carson City that would like to give public comment? Seeing none, we'll close that agenda item and we will move on to agenda item number 3, approval of meeting minutes from June 4th, 2018. Do I have a motion?
So moved. Move to approve, rather.
Okay, and a second?
Second.
Okay, all in favor, state aye.
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 Aye. Aye.
Opposed, state nay. Motion passes. All right, let's move on to, I want to go ahead and start today with agenda item number 7, discussion and recommendations regarding healthcare expenses. And I know, David, you have some information that's been provided to the committee, if you'd like to present that.
Thank you. I provided 3 pieces of information. The first is a page titled Guideline Committee Medical Support Background Information. Last hearing there was the question. I raised, first of all, the issue that federal regulations require that child support guidelines mandate one or both parents provide health coverage if it's accessible to the child and reasonable in cost and available to the responsible parent. And the question was asked if the committee has authority to address health care coverage, and yes, they do. I provided the authority in this first document. Basically, Section 8 of AB 278 says that the regulations must be in accordance with federal requirements, and the sites are there if anybody needs it to take you back to the requirement. The second document I provided is entitled Proposed Healthcare Coverage Language. My suggestion is in italics. The rest of the document is taken from the working document of the proposed regulations that the committee has been working on. And that suggested language reads, every court order for the support of a child must include a provision specifying that one or both parents shall provide coverage for health care for the child under a plan of insurance, including without limitation the payment of any premium, co-payment or deductible, and the payment of medical expenses. A medical cash provision may be ordered if there is no plan of insurance available that is reasonable in cost and accessible. And that last sentence is what the Office of Child Support Enforcement is really interested in, that medical cash is awarded in lieu of health insurance that when it doesn't exist. The third document is an email of that we received from the Office of Child Support Enforcement. The address says from Donovan Tracy, ACF. Ms. Donovan is a program specialist in Region 9 of the Office of Child Support Enforcement. And in this document, the federal office provides their guidance and rationale for the health care coverage requirement.
Okay, any questions or comments regarding this issue?
Sorry, Judge Houskin, I'm trying to envision taking this out to a logical conclusion, and I'm envisioning someone filing a motion for order to show cause why a parent should not be held in contempt for not providing health insurance, which concerns me. I guess, is probably the simplest way to put it. And my question at the last meeting had less to do with offsetting or dealing with the issue of cost of health insurance than us mandating, similar to the federal regs, health insurance coverage. So I have a concern with regard to the consequences of requiring it.
This Dawn Throne, don't you already have that problem? Most of my orders require one or both parents to provide the health insurance.
And I agree, that is in a lot of the orders moving forward, or moving backwards, I guess, in what we're trying to do. But I don't think that the current statute requires a policy of health insurance coverage. It strikes me as potentially causing more problems.
Okay, but
This is Karen.
go ahead, Karen.
So right now, we always address health insurance in our orders in Clark County. We never have an order that does not address health insurance, and especially in light of the Affordable Care Act and the penalty for failure to provide health insurance, we are very careful about ordering health insurance, and in cases where we are unsure if the health insurance is available to the non-custodial parent, for us it's safer to ask that petitioner be ordered to provide it, because the problem comes when a respondent or a non-custodial parent is ordered to provide health insurance and then does not provide the insurance, either because they lost their job or they can't afford it, and then the custodial parent is penalized after the Affordable Care Act. So oftentimes we find that it's safer to order the petitioner to provide it. That way she's always aware of what the policy is, or for both parties to provide. And then hopefully the order to show cause is minimal. But we have that ability now to move forward with a contempt for failure to provide health insurance.
Keith Pickard for the record. It seems to me that we already have, and I'm looking in the NRS, it seems to me we already have a provision that requires us to consider it, and that parents are required to provide it, provided it can be obtained at reasonable cost. From a policy perspective, I don't have a problem with this, that we should be discussing health insurance and having parents that can obtain health insurance to do so, provided it can be obtained at reasonable cost. Now, with respect to the Affordable Care Act, the individual mandate has now been repealed, so that's no longer an issue in terms of penalties. But I think the expectations, at least in my cases, have been that we do. When the parents are able, we do require that they provide it. So just as a policy point, I don't have a problem with this paragraph were we to add that it shall provide coverage for health care for the child under a plan of insurance available at reasonable cost.
And I wouldn't have a problem with that, either at reasonable cost or reasonable policy of health insurance, or if available. And I know the 4D cases, it's typically the if available through their employer language is included in that order. What I'm trying to avoid is me having to hold somebody in contempt and sanction them because they can't afford to purchase health insurance.
But of course, Judge, further down, we still have the original language regarding definition of medical support and what is reasonable.
Keith Pickard for the record,
Yes.
which is, again, why I think we should add that up top, because the definitional section doesn't make much sense if we don't include the language in the requiring statute.
Okay, so what was your proposed edit to the paragraph? State it again, please, Assemblyman Pickard.
It would be following the words under a plan of insurance. Okay, so end of the second line, we would add, provided it is, well, here, I'll just read it. Parents shall, this is the second line of that italicized paragraph. Parents shall provide coverage for health care for the child under a plan of insurance available at reasonable cost. Or as Judge Hoskins suggested, maybe we say a reasonable plan of insurance or something like that.
Why wouldn't we just change it to shall provide coverage for medical support, and the medical support's defined below?
Oh, that's okay too. If we want to refer to that, that's fine.
David, do you see a problem with that?
But if you just say medical support, doesn't that leave the option still to order medical cash in lieu of health coverage when health coverage is available at a reasonable cost to the responsible parent? And I'd also
Yes,
like to...
but is that a problem?
Well, the Fed's intent is that, and their interpretation of their regulation is that healthcare coverage is ordered if it's available. Medical cash only is in lieu of health coverage when it's not available or reasonable cost. And there's a third component, and that is accessible to the child. And that accessibility is defined also in what's already drafted.
And I think if we include that if available language and the other language you've indicated, then I think I'm okay with it. If we're complying with the federal guidelines, I've got a hard time holding somebody in contempt for not providing health insurance that either isn't available or that they reasonably can't afford, is my concern.
But when in those circumstances would they not be on public support at that point?
And that's also acceptable.
And that's acceptable under the language that's here. I mean, you're talking about some narrow margin of people that don't qualify for public support, which is acceptable under these definitions. I don't know.
Well, and I think, and I don't know that I disagree with you, Madam Chair. It's just
Right.
that if I take the strict language as presented in the italics, without including either if available or reasonable or going to medical support, I can see strict reading of the law, me being able to find them in contempt. And I don't know that's the intent of this committee is to punish people for not being able to afford health insurance, but to make adjustments to the cost of child support based upon the reasonable cost of health insurance. So it's unintended consequences is all I'm trying to avoid.
But you're not suggesting deleting out the medical cash provision, correct?
No, I'm not
Okay.
suggesting that.
So if that's still in there, the medical cash provision with the additional language, if available or reasonable in cost, we should still be in compliance.
Correct.
Correct, okay. All right, any other?
Madam Chair, if I
Yes.
may, as I'm looking again at subsection B, this is talking specifically about cash for medical support. So I think my personal feeling is we should probably stick with what we have, provide coverage for health care for the minor child under a plan of insurance provided it's available at reasonable cost.
Well, it's payments, under B, payments of cash for medical support or the cost of coverage of health care are reasonable in cost if. It just defines what reasonable in cost is, really.
Yeah, I just, the way, and it may be just because of what I had for lunch, but the way I'm reading it at the moment, I would like to see that up top. I just think it makes it clearer.
Okay, so at the end of the second line of David's language, under a plan of insurance, you want to state if available and reasonable in cost, or what are you suggesting?
I think just available at reasonable, if available at reasonable cost. Because if it's unavailable entirely, then you still meet that language requirement. It's not available at reasonable cost. I don't think we need to separate the two thoughts.
Okay, other thoughts from other commission members? Mr. Sanford, you're reaching for your button.
I was just going to say that if we're adding the reasonable in cost to the top language, we should probably say that is reasonable in cost, or perhaps that is accessible and reasonable at cost. Accessible is defined in sort of that same way in the same part. So anyway, it would bring both those pieces within the top language for the plan of insurance being accessible and reasonable in cost, and then those are defined terms later. But other than that, I like
don't have a problem with that.
Additional comments from the committee? Do we have a motion?
So moved.
All right, let's be clear. The motion is to add the first paragraph of additional language that David proposed, and I'm just going to read it so that we have a clear record. Every court order for the support of a child must include a provision specifying that one or both parents shall provide coverage for health care for the child under a plan of insurance that is accessible and reasonable in cost, including without limitation the payment of any premium, co-payment, or deductible, and the payment of medical expenses. A medical cash provision may be ordered if there is no plan of insurance available that is reasonable in cost and accessible. Do we have a
I
second?
believe it should,
Oh,
that
okay, go
is
ahead.
accessible and available at reasonable cost.
At
I
the
think
end
that's
of that,
what
at
we're
that last sentence, okay. That is,
Yes.
that's why I
No,
wanted
we
to
already
read
have
it.
disagreement. Yep.
This is Karen from the DA's office. I just want to make sure we clarify, because I think our intent is to make sure that it's accessible and reasonable for the non-custodial parent to obtain. We just want to be careful where we place those, because if the child is living out of state, is it accessible and reasonable to cover the child? Sometimes if it's placed at the end of the sentence right there, it's not clear that it's accessible and reasonable to obtain the health insurance for the child versus the accessible and reasonable if the child's living out of state. Insurance doesn't cover the child out of state. I don't know, is that just me, or is it clear? Maybe it's just me. Putting it out there.
I might suggest that instead of using that, I would say if, because otherwise we're saying you have to obtain a plan of insurance that is accessible. It's if it's accessible and reasonable at a reasonable cost. And to me, frankly, it sounds clearer to me if we insert that language in the first line rather than further down. Every court order for the support of a child must include a provision specifying that, if accessible and available at a reasonable cost, one or both parents shall provide coverage. It just
Yes.
reads better for me.
Agreed.
My mic's not on.
So I believe it then is, every court order for the support of a child must include a provision specifying that, comma, if accessible and available at reasonable cost, comma, one or both parents shall provide coverage for health care for the child under a plan of insurance, and on.
Yeah, I was trying to keep the exact phrase reasonable in cost just because that's what's defined in quotes below. So I was keeping that word in between reasonable and cost. I know it sounds silly, but
No, for consistency, that's probably smart, so that's fine. So I'll amend the motion to, so that it reads, every court order for the support of a child must include a provision specifying that, comma, if accessible and available in
Accessible and
If
available.
accessible and reasonable in cost, comma, one or both parents shall provide coverage for health care for the child and on as provided in this paragraph.
And then the edits to the last sentence.
I don't remember what they were.
A
I
medical.
think you've got to make it consistent. And I think you've used the word accessible in the first sentence, so you probably need to have accessible in the last sentence. And maybe in lieu of available, make it accessible so that we're maintaining consistency throughout the paragraph.
So you're suggesting that if there's no plan of insurance accessible and available, accessible and reasonable in cost?
I didn't write down what the original language was. My concern is just maintaining consistency, so there's no argument that the last paragraph is doing something different than the first paragraph. I'm sorry, the last sentence is doing something different than the first sentence is doing in the paragraph.
Yeah, so it would read, a medical cash provision may be ordered if there is no plan of insurance that is accessible and reasonable in cost.
That's fine.
Okay. So,
This is Karen.
yes, Karen.
Sorry, just real quick. The payment of medical expenses, that's a curious provision because in the 4D program, we don't assess payments on medical expenses until medical expenses have been reduced to judgment in the family court. Once all of the medical bills have been litigated, there's been a judgment. At that point, the 4D program will assess a payment on medical expenses. So for every court order to always be setting a payment on medical expenses, maybe that's just a confusing part of the paragraph for me. But
David, is the additional medical expenses part of the federal rule?
No, it's not, and I do agree with what Ms. Cliff is saying.
So the proposal would be to delete the words "and the payment of medical expenses"?
I'm okay with that.
Okay. Now, mind you, typical custody orders would still a lot who has to pay, that they have to share it.
Yeah, but that's a separate provision.
That's a separate provision.
And it's
That's
also
a sep-
included in the 4D orders.
Right, okay.
This is Joe Sanford. I just have a quick question as far as the medical cash provision in light of all of our orders contain similar language of a sort of a 30-30 rule regarding the equal payment of all medical expenses shared between the parents, as well as if there is no health insurance, that is generally, still a split cost. How does the medical? I don't do a lot of medical cash orders since we don't do the welfare cases, but assuming that those costs are still split equally between the parties, where does the medical cash provision, is it something that is typically always ordered, or is it just something that I guess here it says may, but I know our hearing master gets frequent comments in the welfare cases that I don't handle about it being asked for in every order. And so I'm just curious as to if maybe someone has more information on what the medical cash provision's intent is if all medical expenses are still split.
the medical cash provision is only for the monthly premium. The 4D program doesn't litigate medical bills, but the premium that's where the med cash fits in. So if the petitioner's monthly premium is $200 per month, they have to share it 50-50, then the medical cash provision for the non-custodial parent would be $100 a month, so long as that doesn't exceed 5% of their gross monthly income.
Well, the way I read all of this, in this language we have, that if you have an unreasonable premium, then the theory is it's not going to be 50%. It's going to be a cash provision, meaning that's the reduction part of it, right? Is that? I understand what your issue is with it, because
I guess my thought is it says here a medical cash provision may be ordered if there is no plan of insurance available that is reasonable in cost and accessible. And because the earlier language says specifying one or both parents shall provide this coverage, so that would cover either parent. So this would say if neither parent has a plan of insurance that is available at reasonable cost, then we would enter in this medical cash provision. So that would mean there is no plan of insurance, so there is no premium that we're covering, unless I guess I'm missing something, unless this would be only in the case of an insurance plan that is not reasonable in cost but is still being used. And
So
then
that's probably that's a drafting issue then, because I think the intent of the sentence, if neither party has health insurance, there would not be a medical cash provision. Medical cash is just for the non-custodial parent to participate in the contribution for 1/2 the monthly premium. So if neither party has health insurance, we would not enter into a med cash situation. But I think I can see how this would be a drafting issue. I think the intent of the sentence, and of course Mr. Castanola would probably be able to elaborate. I think the intent of the sentence is to say a medical cash provision may be ordered if the respondent, the non-custodial parent, does not have a plan of insurance that's available. So if he doesn't have a plan of insurance available, then he is to contribute monthly, which is what we do now in court. If the petitioner is the only one with health insurance available, then petitioner is ordered to provide health insurance on the court order, with Medcash being ordered. And that would increase the non-custodial parent's monthly obligation. If neither party has health insurance, at least in our courts, there is no Medcash provision, because there's nothing to assess a cost for. So I don't know if that sentence just needs maybe some additional wording, but I believe that was the intent of the sentence.
That is the intent.
I'm wondering if I may, Ms. Cliff, what happens when the petitioner does not have insurance available, but the respondent does?
So in those instances, and the child is not receiving state medical, so we generally ask the parties how they want their order. Do they want the order to reflect respondent to provide? But if he does provide the health insurance, then he's going to receive an offset on his child support. And some petitioners don't want that because they know, next month they'll be employed, they're going to have health insurance, they don't want their child support facing a reduction, in which case petitioner would be likely ordered to provide. Or we ask them, do you prefer if both parties provide so the child is double covered?
again, this is Joe Sanford. So at least the way our court handles it is just if the respondent is providing coverage, then he gets a deviation downwards. If the petitioner is providing that same coverage, he gets there's a deviation upwards instead of calling it medical cash. So I guess I think that is how it's currently being done. I'd have to recheck our master document as far as whether there's any problem with deviating upwards, but that is how, at least in our court, the medical coverage is done when petitioner is providing, is by providing a deviation upwards of half of the cost. Looking at this language, I guess my concern is where it says if there's no plan of insurance available, that would mean that there is no insurance plan, and so there would be no medical cash in that situation. So either...
So if you look on the first page of the background information from David at the very bottom, the last bullet point, where it says OCSE has advised the Nevada Child Support Enforcement Program, that 45 CFR, anyways, that number, means that a state's child support guidelines must require health care coverage, but a medical cash provision may be ordered in lieu of health care coverage. those are words that we're missing on the other side in the language. When the healthcare coverage is unavailable, inaccessible, or not available. I think it might be important to add the words in lieu of healthcare coverage, because we're truly talking about there is just no coverage because it's way too expensive, or I would assume we're talking about the people. It's way too expensive to even reasonably get, and they don't qualify for public benefits because their income's too high, and those two issues have left them health insurance less. And so at that point, the court can say, you may not have insurance, but on a monthly basis, I want you to pay X dollars to the other parent for the purpose of assisting with medical costs. Am I interpreting that right? That's that circumstance right there. That's the issue.
Yeah, and if you refer to the email from the federal representative on the first page, towards the bottom, capital letters response in the first sentence, the federal representative cites the regulation, and that the regulation means that a state's child support guidelines must require health care coverage, but a medical cash provision may be ordered in lieu of health care coverage when health care coverage is unavailable, inaccessible, or not available at a reasonable cost.
This is Kathleen Baker for the record. I guess for me, and our agency works quite a bit like Clark County and Churchill does, we use medical cash as when the petitioner is providing insurance and the respondent is going to be covering part of that insurance. I think the question that I would have is, if we're talking about medical cash, how do we calculate that? Because I think of medical cash as being something available for a child's medical needs, but what if they don't have any? How do we assess? It's like assessing medical expenses when we don't know what the expenses are going to be. And so are we going to have to come up with a sub-formula to determine, if we don't have insurance available, what the medical cash is going to be for any particular situation?
I'm so confused. We only use medical cash when we have a known cost from the petitioner. So this medical cash when there's no plan of insurance, like I said, I think this was just a drafting error. It's supposed to say a medical cash provision may be ordered if there is no plan of insurance available to the non-custodial parent. We only assess in Clark County, we only assess med cash when the petitioner has a monthly health insurance cost. And we can only assess the health insurance, and this is the monthly premium, not medical expenses. I just want to keep reminding everyone, 40 program cannot assess medical expenses. It's the monthly premium. That's all that MedCash is. So
well,
if the
that's
monthly
what
premium,
your
like
MedCash is, but that's not the way the feds are writing MedCash in here. They're saying,
well, David
look, you don't have.
was present.
Yeah, we just read it.
Maybe. Yeah, so maybe David can, but my understanding is medical cash is when the petitioner has health insurance. So you take the petitioner's monthly health insurance expenses for the child only. So we always remove the petitioner's expenses for the health insurance. It's the cost for the child only every month, half of which is taken and assigned to the non-custodial parent as MedCash. If my understanding is different, like I said, Mr. Castanola would know more in that area, but I would love for him to weigh in. But I think it's unavailable to the respondent. We've already received clear directive that Medicaid or state insurance, whether it's childless adult or Medicaid, those provisions are acceptable forms of health insurance.
I don't believe that the federal government intends to get down to this level of detail in their direction. They do want to leave a certain amount of latitude to the state. Now, as far as on the state handled 4D cases, yes, we do the same thing as Churchill has indicated and Clark County's indicated. As far as medical cash is for the premium.
That's how you've dealt with it historically.
That's correct.
versus the way the feds are using the word or the language medical cash here. Because it says point blank, in lieu of healthcare coverage.
Yeah, I yes, that's what it says, and I believe that they could have continued that sentence to say accessible to the child, reasonable cost to the obligated parent, and the obligated parent could be either.
Can I perhaps make a suggestion? That I think we're getting hung up on the term medical cash.
Yeah, I think so too.
That I think it has different meanings depending on who's using that term. And I'm not clear if it is a term of art, either in the federal regs or in the 4D program. But it appears to me, listening to the conversation, that we're talking about two different things. That perhaps if we changed medical cash to something more descriptive rather than a term of art, that we might get past this issue.
And for the record, this is Kathleen Baker. You all probably know I've been in the 4D program for less than a year. And every time that I talk about our audits for medical cash, when I talk about it in court, I always clarify by talking about it being an insurance premium, because it's never made any sense to me to call it medical cash when what it really is the premium cost. So I think it is about semantics.
And Stawn thrown in the private cases, we're always just calling it an upward or downward deviation from the child support, depending on who's paying the medical insurance.
It's almost like a self-insured language, unfortunately, in the way the feds got it.
This is Kathleen
Right?
Baker again. I actually agree with Karen Cliff's interpretation in looking at the first page of the medical support background information. If in the 4D program, what we're talking about is medical cash being half of the insurance premium that's being paid for by the petitioner. If you go down to this, and you talk about medical cash, so the obligor doesn't have health care coverage, but the obligee does. So the obligor can be ordered to do medical cash if they don't have coverage. So if they don't have coverage provided for the child, then they can be ordered to pay half of the insurance premium that's being provided by the custodial parent, or however you want to refer to that parent.
This is Joe Sanford. Just as additional background as far as Churchill County is concerned, the welfare group that comes out, or at least as far as the hearing master has referred it to me for the purpose of bringing it up on this commission, they ask for it, I believe as Ms. Surratt interpreted it, which is they ask for a 5% is the standard anytime there is no health insurance available, as just a cash basis. It's not for a premium. It's not calculated as anything else. It's just a 5% of the gross monthly income cash cost, theoretically to be used for medical costs, even though there are no known medical costs. And so that was brought to my attention by the hearing master in Churchill County as something that she wanted me to bring up in this commission, because she didn't understand exactly what the basis for that was. I didn't have better information. So at least in some counties and in some offices, there is an interpretation that medical cash, as written in the federal regs or in our in the language there is in lieu of health insurance, is just supposed to be some percentage up to 5% of just a payment to be made to the obligee, I guess sort of to cover medical expenses. I understand the basis for that in the sense that it is difficult to get a medical judgment to be enforced to recover half of those costs under an order, which is how our office and I think all of the 4D programs work. Is we do not collect any money on a medical piece unless it is reduced to judgment. And so in cases where it's likely that an obligee will not be able to actually go to court and reduce those pieces to judgment, the interpretation has been that this 5% of a gross monthly income is supposed to cover that. At least that's my thought of what that was sort of supposed to be for. But it was something that came up in my hearing master's opinion about something that she currently doesn't really understand much, and I saw it in this language, and I guess I wasn't sure if if the interpretation was supposed to be that it's supposed to be sort of 5% to cover unforeseen medical costs in lieu of having health insurance, and then I don't know how they split the 50-50 if it does get reduced to judgment. That sure seems like double dipping, but I guess I would like to see if that is the intent of the medical cash provision, is to sort of get around the need to getting a reduced judgment for medical support. That would be something that I would at least want to know if that's the intent, because I think that that's something that we have a hard time collecting in the 4D program. And anyway, that I think that is a concern. It is something that comes up in various courtrooms, at least the way the language is drafted now. And I think that the language as was proposed is how it is currently being interpreted, is when, or at least in my county, when there is no insurance available for either party, that the obligor is assessed, at least as recommended, 5% of the gross monthly income for the purpose of providing unknown health care medical costs for the child. And then I suppose if it was ever reduced to judgment, we would still collect again on that.
So when I back out of it and I take a good look at, okay, we've really tried hard to not get obsessed in this language about a different calculation for obligor versus obligee. I mean, my thought was the medical support language was always supposed to be stop, despite who's the obligor, despite who's the obligee, this child needs medical support. And now we're going to figure out that cost between the two people involved with this child that we're doing our child support calculations for. And we do have a little bit of payer language in here when we've been trying really hard to use obligor and obligee. So to keep that clear. On the federal language, despite what any of the counties are doing, despite what Clark County's doing, the language here was very clear that this medical cash provision is in lieu of health care coverage. And just those pure, simple words, despite what everybody's doing or not doing, it's when it's in lieu of health care coverage because it's unavailable, inaccessible, or not a reasonable cost. Then we've got this quote-unquote medical cash provision issue, which, like Judge Hoskins said, may be an issue of definitions, term of art, and that may be where we're having problems that I want to get to the bottom of. Yes, David?
The language in the federal regulation, 45 CFR 30256, B2, is simply address how the parents will provide for the child's health care needs through private or public health care coverage and or through cash medical support. Now, in their guidance, the federal office goes on to say that health care coverage should be the first option. And maybe in an effort to standardize it, it's become too complex. What's wrong with the language, the existing language in 125B085, which AB 278 repealed, affected the regulations, but why not put that existing language in the guidelines? That seems to work now.
The existing language. Okay, let's pull that up. I do.
While we're looking at it, the other thing, if you go to page 2 of the email, and you go to the second paragraph, it actually says the last line, in appropriate cases, cash medical support may be sought in addition to health care coverage. So it seems to me it's clearly two different things.
Madam Chair, I actually, I'm looking at 125B085, and I like the idea of just taking this section out. We can delete this last sentence from the italicized and reinsert 125B085 because I agree with Mr. Casanova that this is working There doesn't seem to be a great deal of confusion. This isn't a problem that came up during the discussion of the bill, and so maybe this is not a problem that needs to be, maybe it's not a problem to be fixed. I like the idea. Yeah, if it ain't broke, don't fix it. Yeah, I'm having people tell me there is a motion on the floor, so why don't I just withdraw that motion for the moment, and we'll come up with a new one.
Okay, yeah, because you made your motion, and then we tried to clarify what it was, and we never got to the end of that. So I have 125B 085 in front of me. Order for support to include provision regarding medical support for child. And this was repealed, AB 278 repeals 085 in its totality. And does anybody need me to read it, or do we all have access to it? Anybody? Okay. Take a moment to review it. I think one of the biggest things we changed when we started kind of messing with this language is we, of course, put in the court shall consider the reasonable cost, but within the original 125B 085 language, it does say that the court must include a provision specifying, and it goes on about the medical support.
And Madam Chair, if I recall correctly, the reason we pulled 125B 085 into the bill was because it deals with it, and we just intended to move this consideration into the calculation. So we had to include this so as to avoid a conflict. But I don't recall anybody ever saying that this was a problem that we were struggling with that needed to be changed to comply with the federal rules. I think we're safe if we keep this.
The concern during the legislature was just whether it was looking like a deviation factor, making our national statistics not look as good. Ms. Baker?
That's right, and if we since we've shifted the consideration in the calculation so this isn't a deviation, it's now part of the calculation. I still think that the language under 085 works.
And there's no prohibition against, I'm sorry.
Go ahead, David.
There's no prohibition against deviations. The federal requirement is to minimize the use and standardize where possible. And the consultant, Jane Vanore's report, said that we might do a little better as a state in standardizing some of the deviations, but they can still exist.
Correct. Ms. Baker?
Kathleen Baker for the record. So one of the things that we did when we looked at this is we deleted out the co-payments and deductibles and payment of medical expenses because those would not be easily calculated into the formula itself. So when we were looking at having a formula that minimized our deviations, we were looking at the cost of the insurance premium, which can be easily determined versus what the medical expenses will be, which are variable for any family.
that's where in the statute is that exact language? Sorry, I'm in 085. It goes on 2 pages, subsection, just for a clear record here. Under number 2, so 125B.085, subsection 2 is exactly what she was referencing. That medical support includes without limitation coverage for health care under a plan of insurance that is reasonable in cost and accessible, including without limitation the payment of any premium, co-payment, or deductible, and the payment of medical expenses. Although that's, again, part of assessing a insurance policy for its reasonableness is looking at how large the deductible is, not just what the premium is. If you might have a decent premium, but a $20,000 deductible. I don't know that it's necessarily bad language. It's just that we had excluded it, is what you're saying.
Well, in the definition of medical support, we decided that medical support was going to talk about the insurance premium because we could identify clearly what the cost of that is in building it into the formula. So this definition in 0852 talks about the health care plan, but then it says including without limitation the payment of the premium, which is what we were limiting it to, but it goes on to say co-payment, deductible, payment of medical expenses. So if we're looking at medical support and trying to build it into our formula, I think we have to have a definite amount that we can work with. If we're looking at co-payments, deductibles, and medical expenses, that's what's not easily determined because it varies so much. So perhaps we could do a variation and take that out of 085. We still have to deal with the fact that the parents would share in any unreimbursed medical expenses, which would be the co-payment, deductible, and the other medical expenses. But I think what we're trying to do in our formula is to build in the premium amount so that we get rid of that potential deviation, the cost of insurance premium.
Keith Pickard for the record. I recognize where you're going with that because it will make it easier to calculate. My concern, however, is that in real life, the co-payment and deductibles, let alone the payment of medical expenses, but they are somewhat known, but more importantly, those, as we just said, can be more impactful than the premium itself. So I don't think I would want to take that out of the consideration at this point. Yeah, we may not be looking at hard dollars, but in terms of co-payment, we usually do know on a percentage basis what that means. And then the deductible is a hard number. We know what that deductible is, and that's an out-of-pocket expense. And so to the extent that these are definable, the medical expenses themselves may not be, but the premium, co-payment, and deductible certainly are understandable from the outset. And so I think that those should be part of the consideration when we're looking at the expectations for that insurance.
Additional, I know a bunch of people are reading right now and trying to take a good look at it. Any thoughts on that from the commission? Mr. Sanford?
This is Joe Sanford for the record. I understand Mr. Pickard's point. I guess I think that it's two separate issues. The premium is something that we would consider in our formula for determining what the base child support amount would be. And then the standard 30-30 rule in pretty much every order I've ever seen, splitting unreimbursed costs, which, like was said, I mean, that may be more impactful than the premium itself. And so, that is something that would get addressed, if it's thousands of dollars, by the parties on an individual case-by-case basis, rather than trying to guess up front what those costs would be, assuming you ended up having to meet your deductible or whatever each year. And then I think that that makes a little bit more sense just looking at the 125B.085 language as it currently is, which defines medical support as including payment of medical expenses, but then also saying the cost to each parent who is responsible for providing medical support. I'm sorry, the part 125B.080 or 085-2A2, in the case of cost of coverage for health care under plan of insurance, the cost of adding a dependent child to any existing coverage, the difference is not less than, or is not more than 5%. So if we were to say, we're adding a child to this plan, and we're saying that the 5% difference in the cost of coverage, I mean, are we including the co-payments and the deductibles and payment of medical expenses in that 5% calculation, which we've never done? I've never done. I've always considered it just the premium, which I think is what our proposed language sort of clarifies, is that, that 5% is just the premium, and then unreimbursed expenses is something that's going to be covered, and it may vastly exceed 5%. In any particular case, but the parent is still going to be obligated to pay that, and there isn't going to be an argument that because it's more than 5%, it's unreasonable in cost because the copayment's high or deductible is high.
This is Karen. I think that just comes down to defining what medical support is, because the 5% is on gross monthly income. So I think the 5% isn't confusing. It's 5% of the obligor's GMI. It's in the case of payments for medical support. So once we define medical support, and that may be a premium or a copay or a deductible, I think at that point that would clarify whatever paragraph we're looking at. That's just how I see it.
Well, that goes back, that backs what Ms. Baker's saying, which is, I mean, really, if it's, as a commission, we have to really, the problem with insurance, we all know, is the premium really doesn't mean much at the end of the day, right? Because if you are obligated to pay a huge percentage of every medical bill, and the insurance is only, your premium might have only been a tiny amount per month, but if you're out of pocket and your deductible and co-payments are so large that it's unreasonable again, we don't want, I hate to only look at premiums knowing what I know about insurance policies that are out there.
And that was going to be my point too. I really do like the idea that we go back to 085 as it is. I understand the desire for narrowing the view, clarifying what we're looking at, but in reality, I think that the courts are all going to be considering the copayment and deductibles. And as Mr. Sanford suggests, the medical expenses are typically a separate paragraph where we reimburse them or we cover them 50-50 on 30-30 rule. But I think it's probably a mistake to remove from the courts the ability to look at copayment and deductibles as we consider this. Again, if it ain't broke, don't fix it. This has been working okay. There was no discussion that 085 operated contrary to the federal guidelines. So I personally would be more comfortable just taking 085 and inserting that in lieu of this italicized language.
This is Bridget Robb.
This is Dawn Throw.
Yes,
Sorry, Judge Rob, go ahead.
Judge Rob, go.
And I completely agree with Assemblyman Pickard. I think that I have not personally seen a problem with how this works in my courtroom, and I'm not a fan of changing things just for the sake of change.
Okay. Ms. Throne?
I guess I disagree. I think you should break it down. In step 3 should be a very simple either add or subtract from the child support obligation half of the medical insurance premium, then put the issue of deductibles and other medical expenses, because you're right, they could be a lot in a very specific case. If someone has a family deductible of $10,000 per year, that could make medical coverage or medical treatment inaccessible for the children. That's something that should be in the deviation factors, and we already have one that talks about any other necessary expense for the child. We could clarify that language to include medical insurance not premiums, deductibles, co-pays, co-insurance, I think is the other term they use.
Okay, but if we adopt this right where we have the current medical language in the master document, and the language, I mean, obviously we adopt it minus, we don't have to talk about the June 2nd, 2007 date and stuff, but it does say must include a provision that every child support order must include. Still fits right where we have it. And you disagree on the premium, copayment, or deductible part about it, but it's really just in the definitions of what medical support is that really leads into what's reasonable and what's not reasonable. So, I mean, I get deviating later on because they ultimately have unreasonable medical costs. For example, you have a child who is eggshell child, I was thinking eggshell plaintiffs, but who has serious medical issues. Yeah, there may be deviations still necessary beyond even this provision, but really this is all just about defining what's reasonable. And the other change we had made, quite honestly, we had also talked about vision and dental being considered in our prior language. That's not in the old statute. We had included dental and vision.
Right, when we debated this before, if you go down to under choice A and choice B, as used in this section, medical support includes without limitation the cost of coverage for medical, vision, and dental under a plan of insurance for the child that is reasonable in cost and accessible, meaning the payment of the premium. We did debate that a long time and voted on that language already, that it was going to be the premium only.
I guess as long as we capture the co-payment, deductible, and medical expenses somewhere in this consideration, and somewhere in the steps, I'm okay with separating them, because I do see the point that at this point in the in step 3, we really are talking about the premiums. I personally suspect that the judges are going to consider the deductibles, because those are anticipated out-of-pockets no matter what. And then the co-payment is typically expressed in a percentage form, not in dollars, but I think that those are not going to escape the view of the judge at this juncture. But as long as we don't lose this, I'm okay with pulling that out here and having a separate consideration, but I don't want to lose those entirely, because otherwise I think, as was said before, we then are directing the court to ignore, by its deletion, the issues of co-payment, deductibles, and medical expenses.
Whether it's under the definition of medical support, which you could say medical support is just the premium, and then you could go on later in the parts where it talks about what's reasonable and say the court can look at the co-payment, not adjustments, but the co-payment and deductibles as to assessment of whether or not that policy is reasonable. I mean, that's my point, is if you're going to look at a policy, if you only look at the premium, the cheapest premiums out there are the absolute most outrageous out-of-pocket deductibles, co-payments. I mean, they're ridiculous. Just
I agree, and
You
that
can't
is
ignore
really
that. And
my
so,
fear.
whether you keep it in the front end and make it part of the definition of medical support, or you make it part of the definition, the next section, which is the assessment of whether or not it's reasonable, either spot, I don't think that matters so much as I don't want it gone, in my personal opinion. Because I want that assessment to be made as to whether or not it's reasonable. Ms. Baker?
I would concur that it should be included in determining whether or not the premium is reasonable or not, and the insurance policy is reasonable. I would like to see it in that definition versus at the beginning.
And I'm perfectly comfortable with that.
So what I'm hearing right now, if I can summarize a little bit, is that we reinstitute the language from NRS 125B 085 with appropriate edits, obviously, for some of this language about dates and references to statutes. But in subsection 2, we reference just the premium, and that we remove copayment or deductible and the payment of medical expenses from subsection 2. And we move that language to incorporate some appropriate language. I'm going to say we'll have to review this once the language is actually drafted and proposed, to the definition of reasonable in cost. And I would add that it's not really just the copay and deductible, but the maximum out of pocket that policies are being assessed on right now. Am I missing anything? Hearing nothing. Do I have,
We're looking to see if,
Okay.
do we have adjustments that, do we have a place to plug that in, or do we have to create one?
I would put it under subsection, I would put it under 2, subsection A, where it is
I don't want to drop
defining what is reasonable in cost. I would
where
propose
is
that
that?
it's so NRS 125B 085, subsection 2 defines medical support, but 2A says payments of cash for medical support or the cost of coverage for health care under a plan of insurance are, quote, reasonable in cost if, and there's a 1 and 2, that perhaps there
Right.
should be a 3, or maybe it should go as, I have to look at what order it would go in.
I'm with you. I'm
the
sorry.
court.
I was looking in our master document where
Oh.
we were addressing it.
I'm looking at the
but
statute we're adopting.
Yeah, but that's if we
Yeah.
drop that and we go with this. But yes, I see that, and I like that. I like that.
So there would be an additional provision under A about when it is reasonable that discusses the court making an analysis of the policy itself, really. I mean, to summarize it, whether that's copay, deductibles, max out of pocket, but that the court look at that policy to determine its
agree.
reasonableness.
And I think that would fit quite well under A if we insert it as a new number 1 and we just address it right there.
Okay.
Kathleen Baker for the record. I think we should also keep the definition in the term plan of insurance includes the child being provided coverage under a public plan of insurance, such as Medicaid or reduced fee plan, such as Nevada Checkup. I think adding that to the 085 to be clear about that.
From our prior language. Yeah, we went through a lot of rounds to get to that.
This is Joe Sanford for the record.
Yes.
Along that same line, we may want to consider adding under the medical support definition, the medical, vision, and dental piece for the definition of for a plan of insurance, including both medical, vision, and dental.
Can you restate for me? I'm sorry, I lost exactly at which spot. I know we had medical, vision, and dental, but what is your position on where that should be included?
Under the old statute, NRS 125B085, subsection 2, as used in this section, medical support includes, and then without limitation, coverage for health care, and then replacing health care with medical, vision, and dental.
Okay, I see.
Madam Chair, do we know if Medicaid covers vision and dental? I'm wondering if we're creating maybe a problem where we're saying now we can go to Medicaid, but then we're including things they don't cover.
Ms. Priscillius?
Medicaid for children covers medical, dental, and vision. Adults don't get the dental coverage.
Thank you.
Okay. I see some reading still happening, so I'll give it a moment for everybody to absorb. Now, I would say whatever motion we make, obviously this is going to have to be spelled out, placed in the master document for us to take another good look at it. So we still have a little flexibility based on the date on that. Mr. Sanford.
I know it sort of got lost. I don't necessarily want to belabor it, but was there a decision as far as payments of cash for medical support? Do we want to, I guess, define it the way it's being practiced in the 4D program? At least seems to have had it uniformly. Payments of cash being for premium reimbursement, or I guess, do we wish to leaving it the way it is? It says payments cash for medical support. Currently medical support. I guess if we update the definition here to just say premium, I guess I'll have to read the final document to see whether that makes sense. But is the intention for the payments of cash for medical support to be reimbursement for premiums that are being covered by the petitioner, I guess in the unique situation where they are not on public assistance, but do have a plan for insurance on the petitioner's side, and the obligor does not. I guess said petitioner, but I meant obligee.
Honestly, I think my preference would be to stick with what we have, since it doesn't seem to be a problem.
I think I'm on the same page. I think part of it is, I know that strange word of cash right there tends to cause a problem, but the part that I go back to subsection 1, which really then leads into 2 and the rest of this, about every court order for support must include a provision specifying that one or both parents are required to provide medical support for the child, and any details relating to that requirement. Which I guess I would assume the reason in A, it's a little more vague about cash or the cost of coverage, is just because of the issue of whether or not you're dealing with an obligor or an obligee, and who has the policy. And I think the two combined kind of gives that flexibility, but I could be wrong. I think it allows for all those scenarios, whether it's the obligor, the obligee, who has the policy, whether you're the one paying cash to the other person for reimbursement versus the one paying for the policy.
And honestly, it's currently, I think, as may, and so courts are free to do it as they need to. So it's not a major concern. On that same line, just throughout this old NRS 125B085, if we replaced health care with coverage for medical, vision, and dental, under a plan of insurance in subsection 2. I'm wondering if we'll want to make that same change under 2A, where it does say payments for cash or medical support or the costs of coverage for, and then we would replace that health care as well with medical, vision, and dental.
I would agree with that. Any other comments on that?
That makes sense to me. It keeps it consistent.
There's a same correction under 2A2 in the case of the cost of coverage for health care. And again, health care with medical, dental, or medical, vision, and dental.
As well as 2B.
So the generic comment is have it replaced throughout the whole thing. Got it. Replace healthcare with the cost of coverage for medical, vision, and dental. Okay. Anybody want to attempt a motion? Or would you like
I'll
me to do
move
it?
that the chair comes up with language and presents it at the next meeting.
Okay. Do we have a second?
Second.
All right. Any other additional comments? All in favor, state aye. 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 Opposed, state nay. And motion passes. All right. Let's move on to agenda item number 4, discussion and recommendations on how to calculate child support obligations in shared parenting cases. And we'll need to utilize the master document in this discussion. If you turn to page 2, I made an attempt to get us some starting language on who is the obligor. I did go to Wisconsin again, surprise, to help me try to define obligor and obligee. I also, just for the input of the committee, the Uniform Parentage Act, 2017 Uniform Parentage Act has come out. There's going to be changes that we need to make to get ourselves consistent with it. And it's just neutralizing that parent language because it's not always necessarily a parent. It may be, although a grandparent who's adopted is considered legally a parent, but there is a lot of language meant to neutralize our ability to enforce child support and find parentage across the board, to, whether it's a parent in the traditional sense or not. So I did utilize that to really take a good look. I also already see a typo with the word custody, but I tried to write out some language that somewhat codifies Wright v. Osborne. If there's any comments about this language, let's start the discussion. We haven't had it yet. I did put in parentheses at the bottom, serial parenting. This is my position that's in here, that's written in here. It's just some temporary language holding spot that we just leave it. And we've had discussions about serial parenting probably going down the road of just leaving it as an adjustment factor and not actually spelling it out because we haven't been able to figure out a method. That's kind of where I'm at this point, but it's time to have some discussion amongst the committee on this. Any thoughts?
Keith Pickard for the record. My
Yes, sir.
concern, if we don't address it, is that Miller controls.
Miller controls on,
Serial.
no.
I'm sorry, that
Split
if we don't
parenting, but I have
adopt-
language in here for split parenting. Miller is regarding split parenting, not serial parenting. So serial parenting is you
I'm
have
with
other
you. I'm
child
sorry.
support. Okay.
You're right.
And I
Just
did
as a
try to codify something for split parenting in here. That's that last paragraph that starts when potential obligors have 2 or more children and they both have joint physical custody. My
No,
approach in
Madam
that
Chair, I think
paragraph
we've got
is
it backwards.
Okay.
The serial parenting is what language that I'd had discussed before. I don't think Miller is about serial parenting, not
No.
split parenting. No?
Wrong. In Miller, they had joint physical custody of, I don't remember how many children were in that case. Was it 3 kids? They had joint physical custody of 1 or 2, and they had, one of them had primary physical custody of the other child. And that was Miller. That's shared parenting. Serial
Okay, you're right.
parenting is there was a child, you have another child with a different person with a different support obligation. Then you have another child with another person with a support obligation here, and now we're down to the third child with that you had with yet a different person, and figuring out child support along the way. We had discussions in the past on serial parenting that our adjustment factor that tells the court that they should take into consideration other children or other, how do we word it? The legal responsibility of the parents for the support of others would be how the court should consider that. There are courts, I looked at Wisconsin. Wisconsin has an actual formula for serial parenting, but it was so, in my opinion, it was so complicated, so convoluted, so many steps that I just didn't see it being practical. I also think serial parenting is something that this commission easily could in the future revisit and take a really good look at to see if there is a methodology to apply to it. I just didn't find one. I haven't heard anything from this group yet as to suggestions on that, but shared parenting is the paragraph right above that, which is Miller v. Miller. And the approach I put in here as a suggestion is the approach from the Family Law Executive Council's amicus brief, which is you calculate their child support obligation under the formula set forth based on the number of children they each have, and then offset it similar to what you do for just shared custody. You offset it at that point. That seems simple to me. Seems straightforward to me, but I'm all ears. This is time for us to have this discussion. So, Ms. Baker.
So are you suggesting that we use a Wright v. Osborne when there's a shared parenting situation? The same kind of formula?
That would be the paragraph right above that. Yes. I've never had a problem with Wright v. Osborne coming across as working well. I mean, I think it's been fair. I haven't, my personal take is in shared custody, just straight shared custody, joint physical custody, that Wright v. Osborne has been effective. Under a shared parenting model, we've got Miller v. Miller, the Supreme Court's approach to it. The Family Law Executive Council's amicus brief's approach to it was what I have here, which is calculate their child support based on the number of children they each, under the formulas, based on the number of children which each of them owes a support obligation for and offset. When I went to our formulas and I went to our charts and I picked some random numbers and I tried to do it and I offset it, it each time seemed it seemed okay to me. But then again, there's probably 100 different ways we could approach this. I'm throwing this out here as an approach to get us talking because we haven't done it yet on this topic. So, Ms. Baker.
Yeah, my concerns are, I think that with higher income families, that might be a feasible approach. But with lower income families, it really isn't feasible. And I only have one illustration that I've sort of been carrying around with me. So I had a custodial parent. She had primary of one child, and then she shared joint with the other child. Now, if she had primary custody of both children, she would have received like $461.
Under the old. Under our old child support
If-
statutes, right? Or
Right.
did you
So for 18
calculate
18%,
that?
I'm not doing it with the 16%. This is 18%. So let's say she had primary physical with both children. She would end up with $461. The situation, then taking the same figures and having her have primary of one and sharing joint of the other, she ended up with $297.
Under our old statutes. So my question is, have you done I would suggest we try approaching it with these numbers, our current numbers, and see what it comes to.
She's still going to end up with less than 18%, which is what it would be for one child. She ends up with significantly less than the percentage she would have for one child. She has one child, she has another child half the time. She doesn't even have the same amount that she would have for one child. She gets less. So she's penalized because she's sharing custody, and the obligee is sharing custody of a second child. The obligee ends up with not enough money to even cover the one child. So it may work in the higher incomes where you're capping out, but it really doesn't work very well in lower income families.
So what approach do you suggest?
Well, I know that before we go to that answer, because I think that's a good question, if I may, but I think that that's probably appropriate. If she's getting essentially 3/4, 2/3 to 3/4 of what she would have received because she's covering the kids, her parenting time with the kids is about 2/3 to 3/4 of that time. That seems commensurate to me.
I haven't looked at this for a while, and so let me review it one more time. Because I may have calculated this, and I may have given you the wrong figure. The 461 may have been 18% for one child. So let me take another look at this, and then I will come back to it.
Madam Chair.
Yes, sir.
Judge Hoskin, for the record, just before I lose track, not lose it, I'm sorry, that came out totally wrong. Lose track of
Yes,
the
sir.
notes that I took on this, at least to begin with. You caught the typo on the third paragraph, should say custody instead of custody. And I also think if you're leaving in the who is the obligor : you need to do who's the obligor / obligee, so that because we do define that as well. With the last paragraph that we're dealing with there, I think in theory I'm on board with this analysis, but I think it probably needs to be fleshed out a little more. And I know you're just putting it in there for discussion point, but I prefer going down this path than the direction we've received on Miller. I think it's more consistent with the law rather than creative with the law. But I do think we probably need to flesh it out a little more so that it's clearer to the end user on how you're going to calculate this under those scenarios.
This is Kathleen Bakerman. I did have a mess up with that. So if the custodial parent had custody of both children, the custodial parent would receive $640 in child support. If there's a shared parenting arrangement for one of the children only, then that $640 would be offset by the custodial parent's 18% of $343, which leaves the custodial parent with $297 for one child full-time and another child part-time. So it isn't even 3/4. So for one child, it would have been more than that. It would have been more than the 297. She's not even getting, it just doesn't compute.
This is Bridget Robb for the record. I'm concerned with throwing everything out based on what may be outlying factors. I mean, you're right, Ms. Baker. This doesn't sound correct, but if this formula works in the majority of the cases, then I think it's something that we're going to have to take a look at and judges are able to use other deviating factors, if available, to adjust the child support end result.
I guess I would have to say that there are not a lot of these cases. I actually had an influx of about 3 within about a 4-week period, so it seemed like there were a lot. Now I haven't had any for a while. But in the last one that I had, there was no deviation. It was simply using basically the Wright v. Osborne formula in a shared parenting. And so maybe there's some more guidance that can be offered about how to address this issue, because I just see a real problem when you have a shared with one child and you have a parent who has one child full-time and the other half-time and is getting not enough to meet the needs of the children, which is kind of what we're supposed to be about, I think.
So my, I one of the things that seems to be consistent, or I haven't heard this from you, Ms. Baker, is whether or not you even liked the methodology in Miller v. Miller from the Supreme Court or not. For me, it was a difficult methodology. I was, of course, looking for something much more simple, in my opinion. I didn't care for the in conclusion of Miller v. Miller versus. But that doesn't mean that the approach of the amicus brief from the Family Law Executive Council was the right answer either. If anybody's got any additional methods of getting there, or if it needs additional language, Mr. Sanford.
As far as the Miller versus Miller, whether the outcome was right or not, I don't really have a position. I think that it was a solution. I know that just my look at it beforehand had been the thought that a parent who has sole custody of one child and half custody of another child should probably end up somewhere between the 18 and 25% number. And obviously that wasn't always the outcome under the Miller situation, which I believe is what Ms. Baker was bringing to the forefront. But I haven't seen, honestly, this is not a very common problem. It may become more problematic in the future, but I would just say that I have yet to deal with this type of situation in my court. In an actual case, it seems to be fairly infrequent. Which brings me, I guess, to my second point, which is the serial parenting. That is something that I do see very frequently, and it works right now as an adjustment factor. It's something that, if we have time, I would like to perhaps look at, but the split parenting, whether the formula put together by the amicus, I think more closely matched what my, I guess, gut reaction would be when thinking about what a child support order would be in that situation. But the Miller opinion did have, I guess, some arguments to that, and I think they weren't entirely unreasonable. If anyone has more cases that can, I guess, show how it worked in various situations, I think we could look at that. But I liked, just as a gut feeling, the way the amicus brief did it.
Madam Chair.
Yes, sir.
I don't know that we're going any different direction than what was suggested a little while ago, and that was that perhaps we just need to flesh out this paragraph a little bit so that it's a little clearer. But as far as the serial parenting, I'm fine with leaving it as an adjustment factor. I'm not sure it's something that we're going to be able to fix now, and certainly we have the ability as a committee to fix it down the road. So if we can deal with that issue and in order to kind of get us to move on, I'm happy to take a shot at clarifying this last paragraph to bring us a little closer to, well, clarity. That's too many clarities in one sentence, but I'm happy to volunteer for that if we need to get there.
So, I would put very clearly on the record that I think this commission will not be done with serial parenting permanently. Whether it's this body makeup of this commission or not, it will be revisited. I do think it's a problem. I do think it's extremely complicated how to get to the answer. I think based on how much work this commission has done and how far we've come with the changes we have made, that it would be something to really flesh out after this July 1st deadline, after we get a break as a group. I'll put that out there. And that it's something to really dive deep into. So that's my take on serial parenting. And to break this into pieces, on serial parenting with that comment and with the adjustment factor for right now as a solution for right now, does anybody disagree with that or think differently of that? Is that something we can put on the back burner or deal with it the way I just suggested?
Kathleen Baker, for the
Madam Chair,
record.
given that was my language, I will defer to the chair and agree with that. I think that's smart. I think ultimately we've got one more meeting, maybe two, and we've got to have finalized language. And since we're nowhere close on that point, I think we should set it aside for future consideration.
Okay, Ms. Baker?
I was just going to say I concur with your assessment that we should put that on the back burner and leave it as a deviation pick or adjustment factor for now.
Okay, so broke that out. Now let's, I'm going to break this into pieces for right now. The definitions of obligor and obligee, do we have any problems with those? Okay. And we'll do this as a motion, obviously. Other than my typo in the the third part, an individual who is granted primary physical custody of a minor child is an obligee. The non-physical custodian is an obligor. Thoughts?
I might change that to non-primary.
Okay. Other thoughts
Ms.
on that?
Baker, if you can
Yes.
clarify why
Well-
non-physical is a problem?
Well, non-primary physical perhaps, only because oftentimes non-custodial parents don't, it has to do with how they look at it, to be quite honest, because they often have contact with their children and visitation or custodial times with their children, and being called a non-custodial parent is a bit of a hot point.
It's non-physical, it's not non-custodian.
Well, they consider
So
that
you're suggesting non-primary
Non-primary.
physical custodian? So you're
possibly,
you want to add primary.
only because
You
they...
don't want to take out physical.
No, don't want to take out
Okay.
physical, just primary, add primary.
We do have primary physical custody in the first sentence, so, okay. Any other thoughts on that? Yes, Mr. Sanford?
I guess I'm just looking at this. It seems to me that it would make more sense to define primary physical custody as well as joint physical custody, and then with the because the way we've defined obligor is a person who incurs legal obligation to support a child as a result of a court order. So if we defined primary physical custodian as well as joint physical custodian for the second part, and then in our language we would say the
Let me jump in real quick, just because you just hit a sore spot within the family bar, the private family bar, for those of us who litigate custody cases. I thought about that, and I kind of started dealing with it, but the problem is we've got lots of case law. It's almost a whole commission on its own, which really, we do have a custody committee studying these issues. The lack of definition has been a problem for our state. It is a debatable issue in defining it. For those of us that do custody litigation, are any of the others on the committee willing to dive into that snake pit at the moment.
Not a chance.
See, yeah, I would love to. I think it's going to take some work. Thus, I went more along the lines of the thought process being a court will have made that finding and have defined it for the parties. Perhaps that's the missing language here. An individual who is granted court-ordered primary physical custody. Would that, now under Obligor and Obligate, I did add the words result of a court order. Maybe I need that result of a court order language in that third part. Because my assumption then is the definition of that stuff was dealt with in the custody action. But
I think you're presuming that with granted. I think if it's granted, then it's been granted either by stipulation of the parties or granted by a court. I'm not sure you need more than that in there.
right, and then we of course have the 4D problems of people not having their custody resolved and they're just coming in on child support. So that's the other reason why in that third part I didn't have the court order language. Obviously, at the point of child support being awarded, they are an obligor and obligee under a child support order, so I was okay with that there. Ms. Baker?
Now that you bring it up again, so most of the time in our 4D cases, if we're establishing support, nobody's been granted primary physical custody. They just come in and that happens to be what the custody arrangement is. And there's a huge debate when they come in and they say, you know, you can't, my court master says, well, I don't make custody determinations. So they haven't been granted. They've actually been, I guess, determined to be the primary, but they haven't been granted it.
So we take the word granted out and
just say
who is primary, and that gives you
or who has
the
primary
4D.
physical custody.
Who has?
Who has? Yes.
Is or has? Ms. Cliff? I'm looking to 4D for help on this, because this is that little weird nuance between us that do custody cases and, you know.
I liked all of the language that you had written, so sometimes I think specificity can also work against us. So I appreciate the language as it is.
Granted.
I would prefer the is granted to just be has primary or because that is a major part of our cases are cases where it's a de facto primary physical custody, but it is not court ordered and likely will never be court ordered.
But the child support court presumes. They presume that it's been granted, or they can't enter the order that they enter. So it has to take place in order for the order to be entered. If they don't know or they haven't made a determination, then they certainly can't make a child support award.
Ms. Baker?
Unfortunately, that would be news to the court master that I work with, because he's very clear that he does not make custody determinations. But when people come in and they agree that this is the custody arrangement that they are currently exercising, he will then make an award of child support.
But that's contrary to law. You can't enter a primary physical custodial award without making a determination that somebody has primary physical custody. I mean, you can dance around it all you want, but the bottom line is that before they've entered that court order, they have made a determination. They may not have said it out loud or admitted to themselves, but based on the way the law is written currently, you can't enter that order without making that determination. You're not making a custody finding, but you're determining that one party has primary physical custody.
Semantics, and I would agree with you that you do make that determination, but you do not award or grant custody.
Well,
so would you say that an individual who has been determined, a person who has been determined to have primary physical custody?
Well, then you're forcing parties to obtain a determination. And this is also for those parties who are trying to solve this without the intervention of the court. And they can grant it. can they determine it?
Well, that's a good question. But what I can tell you is in practice, no custody determination is said out loud or in any of the orders that we have unless we're enforcing for a custody determination from the district court.
Mr. Sanford? Your finger's close to your button, so if you don't want to speak, you don't have to. But
How about trying to take it back to its basic, an individual who has primary physical custody?
yes.
Would that solve everybody's concern?
Ms. Baker suggested that at one point, and Mr. Sanford did too. Yes. An individual who has primary physical custody of a minor child is an obligee. The non-primary physical custodian is an obligor. Good. Okay. Now, before we do shared custody, can we do a motion on those top three sections and the comments we made about serial parenting being on the back burner for now with the adjustment factor? Or Mr. Sanford, do you have a comment?
I'll make that motion with just one other change, which is to change the word "an individual" in that piece to just be "when an individual," so that it matches the other three situations. So it makes it clear that this would be three different possible situations. When an individual has primary physical custody is first situation. When individuals have joint physical custody is a second situation.
Gotcha.
I would disagree because they're not different situations. You're still defining in that paragraph. The next two paragraphs are giving direction, but you're simply defining who's an obligee and who's an obligor in that third paragraph, similar to the first two paragraphs.
I don't get that, Judge. I think it's consistency in language. Does it harm anything to say when an individual has primary physical custody?
Does it harm anything? Yeah, well, I guess it depends on how far down the rabbit hole you want to go. But I disagree that the third paragraph, the fourth paragraph, and the fifth paragraph are accomplishing similar. They're different. The first three are more similar than the last two. And if you make the third paragraph similar to the last two, you're sending an inference that perhaps it has a different meaning than it was intended to have.
Madam Chair, Keith Pickard, if I may. The first three are definitional. The last two are operational. And so I disagree with the idea that we need to make the third, it's really third sentence, but this third paragraph consistent with the operational paragraphs since it's definitional in nature.
Well, and it raises another issue. Do we need the third paragraph if we have the first two paragraphs? If we've already defined obligee and obligor, do we need to give them...
No, you do, because nothing talks about primary physical custody.
Okay, then do we include that in the obligor? Do we include a person who has primary physical custody who incurs a legal obligation? Or does the primary physical custody infer the legal obligation?
No, I think
it's almost as if
I disagree. I think you're making it
twice.
far too complicated. I really do. I think that, when we say obligor and obligee, obviously we've used the daylights out of those two terms throughout everything we've got here. And it almost could be, that part could probably be put at the very beginning of everything. And even removed from right here. And then it's, okay, who is the obligor and who's the obligee? Obligor and obligee are defined as the people, who has to pay and who has to receive. But then we don't say when they have to pay and when they have to receive. That's why we have to have the part about primary custody, shared, and split.
Right, but then we've kind of,
If you leave out the primary custody, you're just jumping right to an assumption that everybody's got joint physical custody, which is the problem with our statutes right now.
no,
Mr.
well, you're saying, you're trying to define it. You're saying when individuals have joint physical custody.
Oh, you just used when.
No, that's because it's written
That was
there.
on the next one,
It's-
yes.
That's your next, I'm just reading from your next paragraph. When individuals have joint physical custody. And I don't know that
I
I
think
disagree
number
with you, Madam
three,
Chair.
I think
I
the
am
third
making it
section.
harder.
So, Mr. Pickard, you just said that the fourth and fifth are operational. I think the third one's operational. It's also operational. It's the first two are the definitions. The third one's not a definition. It's an operational element of when you have when you are the primary physical custodian, this is how we're going to apply it. This is how we're going to operate.
Yeah, I see your point. Because we define obligor, then we define obligee, then we say, under a circumstance where one has primary physical custody and the other does not, the primary physical custodian is the obligee and the other is the obligor. When individual, I see your point. I still feel like they're different, but I see your point.
So right now, we have a motion on the table from Mr. Sanford to adopt the third.
I withdraw my objection. I see
Section. Okay.
the utility.
Okay. So the motion is to adopt the following language. When an individual who has primary physical custody, typo fixed, of a minor child is an obligee, the
When an individual has primary physical custody, that person's obligate.
Yeah, that person is, you're right. That individual. Okay, so it would state, when an individual who has primary physical custody of a minor child, that individual is an obligee. The non-primary physical custodian is an obligor. Get rid of who is the other suggestion. Yeah, who's kind of. When an individual has primary physical custody of a minor child, that individual is an obligee. The non-primary physical custodian is an obligor. Is that a correct statement of your motion, Mr. Sanford?
That's correct.
And do we have a second to that motion?
Second.
Any further discussion? All in favor state aye.
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 Opposed state nay. Motion carries. All right. Now, let's do the fourth section for joint physical custody. Do we have any discussion on that language? Hearing none, do we? Well, I'll give you a moment.
No problems.
Okay. Do we have a motion to adopt this language?
Move to
So
adopt.
moved.
Okay, Ms. Baker adopted. Mr. Pickard, do you want to be the second?
That's fine.
Okay, any further discussion? All in favor state aye.
Aye.
Opposed state nay. Motion carries. Now, we'll just deal with this last section on split custody. And I want to throw out there for a second. At one point, we had definitions for split. Really, we have a definition within joint. I kind of incorporated that split. I didn't point blank call it split parenting in this last section. I took this language on when potential obligors have 2 or more children and they both have joint physical custody of at least one of the children. It's a mutation between some of the language in Miller v. Miller and some of the language in the Wisconsin statutes, just so everybody knows how I tried to get to that before we even get to the calculation part of it. Additional thoughts? Or are we still stuck on this for right now?
Well, that's just the point I was going to make. I think that I'm in agreement with it in theory. I just think it's not clear enough for the average user to be able to take it all the way to conclusion. So that's what I was suggesting, that perhaps we could flesh it out a little more, and I'm happy to volunteer to do that.
Okay. So with that volunteering, I can put on the next, we'll use that as part of our agenda where we're supposed to look at future agenda items. So agenda item number 9, that Judge Hoskin will work on this language some more, and then I would suggest to the committee to challenge the committee to come up with some other options that we can contemplate and some other language we can contemplate to deal with this issue.
And might I suggest that if anybody has thoughts on it between now and the next meeting, to feel free to email me their thoughts, and I'll try and incorporate it.
Great, I agree. And I would also put out there, unlike serial parenting, that this is an issue we need to resolve by our deadline, in my opinion. Is there consensus on that?
Yes.
That we can't leave this untouched or undealt with? All right. Okay, let's move to, I'm going to close that agenda item then with that. And let's move to, what time is it? We're at 3 o'clock. And let's move to agenda item.
Madam Chair?
Yes.
I don't know if it's appropriate, but I did find a typo in the first paragraph under step 2.
Yes, so
If-
we're
if-
moving to
if-
agenda item number 8, which is review of the master document, where we're going to deal with
Oh,
a
okay.
bunch of those things.
I just
And there's
didn't
some
wanna-
other items
'cause
that
I
are
would forget.
redlined in here we need to deal with. So let's go ahead and go from page 1. And you said on step 2, so that would be page 2. You have a typo, and it's where?
First paragraph, it should be determined with a D by stipulation rather than determined.
Yes. Okay. Then, wow, there's another typo. I'm getting good at this. So it's amazing when you read out or in a meeting that you see typos you don't see at your computer screen. So on page 3, I put in 2 stars. What I did in kind of playing with this document myself is I started looking at the various case law we had in Nevada on child support to see what issues we might be missing. We do have a very specific case, Scott, which is 107 NEV, and at page 841, that very clearly stated overtime is in the definition of gross monthly income. And I assume over time we've kind of just taken that for granted. But my thought was, do we want to include that in our definition of gross monthly income? That case does say gross monthly income includes money earned from overtime pay if that overtime pay is substantial and can be accurately determined. Thoughts?
Judge Hoskin, in my first initial thought is that we should leave it for the court to make those determinations. After saying that, it might not hurt to at least codify what we have in Scott and to indicate salary and wages, including monies earned from overtime pay if that overtime pay is substantial and can be accurately determined. And that way we're codifying what the Supreme Court said with regard to that. The hesitation I have in making that suggestion is that sometimes the more specific we get, the more problematic it becomes without wiggle room. So that I make that suggestion with some hesitation.
I agree, but obviously it was vague enough under the prior definition of gross monthly income to cause a Supreme Court case for somebody to go in and try to argue that overtime was not part of their income. And so I prefer that. And I think the additional language, taking the exact language from Scott, does not harm anything. Anybody else have thoughts on that?
The discussion we're having here is that there's a recollection that Scott talked about regular and consistent with the overtime, or was it specifically, it's been a while since I've read Scott.
The language
Or
I
was
put
it-
in here was from Scott, where if that overtime pay is substantial and can be accurately determined.
Okay, and that may include the consistent, well, or not.
Consistent might lead to being substantial.
True.
That might be what the goal was by using the word substantial. Obviously,
I
we
have a
all
lot
have
of-
the cases where somebody worked overtime. They got this great, brilliant chance at overtime, which never happens in their job, and suddenly, they're only trying
Right.
to use that one pay stub to show what the other party's gross monthly income is, right?
Which is the situation that I'm thinking of. It may be substantial and accurately determined, but it also may be just the summer of 1 year. So do we want to clarify it more than that? Again, the more clarification, I still have concerns that we're going to limit the ability for reality checks.
Keith Pickard, for the record, what if we were to say substantial, comma, consistent, comma, and can be accurately determined?
I like it. I mean, I've had plenty of examples of people who just had that rare overtime incident, and they're testifying up and down. Look, it's never going to be on my paycheck again. I promise. Of course,
Yeah.
it's up to the other party to prove that's not actually true. But there's been plenty of those, right?
I agree with that. I've had plenty of those cases as well. And I do believe consistency in the overtime ultimately probably could be subsumed in the accurately or the accurate determination, but I think it's probably worthy of specifying that really we're talking about consistent overtime, not the one-off. Or even if it's 2 or 3 times a year. I'm thinking if you're in retail sales, you get overtime during the winter period, the run up to the winter break, but it's not consistent every month. And so I think we should add consistent to that, but that's just my opinion.
Okay, I'd make the motion to include in our definition of gross monthly income, overtime, money, back up, to include money earned from overtime pay if that overtime pay is substantial, consistent, and can be accurately determined. Is there a second?
I'll second that.
Okay, second from Mr. Pickard. Any discussion? All in favor state aye.
Aye.
Opposed state nay. Motion passes. Now, I have another note on here, and it may be inappropriate to put in the exclusions, because once you start putting in an exclusion, you start getting in trouble. But again, this came as a result of actually reviewing the actual case law we have and some references in the Wisconsin statutes. And and I looked at our minutes, and we did have a very clear discussion that SSI was not to be included. SSD was a different scenario. We have what it is, but we don't have what it isn't. And it may be totally inappropriate to add an additional note that income derived from SSI cannot be included. But I got super worried about people just not understanding the difference in that.
This is Joe Sanford
Madam
for the
Chair? I'm
Yes.
sorry. Go ahead, Joe.
Thank you. I had a similar concern, especially looking at the the first section where we define what is included in gross monthly income, Section 3, Social Security, Disability, and Old Age Insurance benefits under federal law. But then we also have in our Section 12, what's not included, we have public assistance benefits under federal law, except the child care subsidy payments under federal law, where I think that those are opposing and inconsistent. And I would argue that the Social Security disability as a specifically defined piece would probably trump, but it is, I think, confusing where our Section D is very broad and kind of encompassing of a number of different benefits. I'm sorry, 12D is encompassing of a lot of different benefits. I'm not sure of all of the possible federal benefits that we would be negating by that, when I think the intention was to just negate SSI under that provision. So if anything, I would, maybe someone has more information on why we did 12D the way it was, but at the very least, I think specifically mentioning SSI in the exceptions and then clarifying either D to not include SSDI and old age insurance benefits under D like we had above.
And my recollection of 12D was I think we had SSI specifically laid out months ago, and there was a reason for pulling it out because we didn't want to get that specific. And if we're including SSI, we must be excluding something else. So my recollection is, although it's, like I said, been several months, that was the reason that 12D came up with public assistance benefits under federal law, which I think would probably cover SSI, is my recollection, and I'm certainly, it could be faulty.
I think 12D was added to indicate that TANF would not be considered income, but by putting public assistance benefits under federal law, it encompasses both situations where an individual is receiving TANF cash and SSI. Public assistance, SSD is not public assistance. It's based on wages. SSI, being federal welfare, is a public assistance. So while it may be considered duplicative to have D and G, there's a lot of individuals that may not understand that SSI is a form of public assistance. So I like that it's in G as well as D. I'm comfortable with it as it stands. I believe that was to incorporate TANF cases, TANF cash, but that's my recollection.
And quite honestly, if our 4D individuals are comfortable with it, I am too. I just started looking at other statutes that dealt with this issue, and then I got nervous that people just wouldn't understand that that meant SSI. But if we don't need to separate it out, then we don't need to separate it out. All right. Unless we have a motion on that, I would consider that discussed. Unless
Madam
somebody
Chair,
does
I
want
do
to
have
it.
one thing. And this has come up since we had this discussion. I was made aware of a case where a judge considered a draw on a separate property account as income. It's a one-off. I don't know that we need to address it, but it was interesting in this context in that this particular judge determined that a party had a sizable investment account and was regularly taking draws on that and counted that as income. And that just seemed wrong to me. And so I'm wondering if we want to address that here.
Are you opening the community property, separate property argument again?
No, it wasn't really again.
Yeah.
It wasn't really, I'm not intending to discuss that per se. This was a little different scenario than what I had in mind. And I don't see how this necessarily, if it were an account established as the result of a personal injury award, it would fit under I. But what happens if it's a separate property? Maybe it's an inheritance, and they have, a couple $1,000,000 in the bank, and they're drawing that down. The transfer of money from one account to another doesn't necessarily constitute income. They're living on their savings account, and so it's not income under the rules, but it's something to consider. It's something that came into mind.
And I'm happy to disagree with Assemblyman Pickard.
Now we're back.
That's right. Now,
So let me
interest in
throw
investment
something
income
out there.
number 2 is included.
Hold on, please, Judge.
And investment income.
Judge, please, for a second.
Yes, ma'am.
Assemblyman Pickard and Judge Hoskin, if we could come back to that, I'd like to resolve some of the other kind of housekeeping type edits through the rest of the document, because that's a whole
Happy to.
topic.
My point was it's already been resolved. Was my only point. We've already resolved
You're happy
that.
to, except you want to keep talking about it. Okay, we'll come back to it. Let's come back to it, please. Okay, we're going to skip the medical because we've resolved the medical issue. Let's drop down to the adjustments. There were some edits in the adjustments. And again, that's that Social Security issue a little bit, just something I pulled from Wisconsin. But let's talk about adjustments. Page 7, first paragraph.
I'm sorry, Madam Chair. You've gone past some typos.
Okay,
So I did-
let's back up then. Where at?
page-
If it's medical,
page
we're
4.
replacing medical. Okay?
Yeah, it's in page 4 under imputation of income.
Yes.
It's additions that we made from last time. I just think you should put commas around after taking evidence. If the court determines, comma, after taking evidence, comma, that the obligor.
Okay.
I think that's, I don't even know if we need to vote on that. I think that's just a grammatical
That's
kind of a
grammatical-
situation.
Yeah. Okay.
All right, sorry. Go
Anything
ahead.
else?
No,
Okay.
not before page 7, no.
Okay, so page 7. At some point in all the notes, I found the word exclusive before factors, and then I didn't know if it was supposed to be in here, and I couldn't quite tell from our meeting minutes if that was something we wanted, that, right? That's exactly it. But I didn't have it in the master document. Does anybody recall if we wanted the word exclusive before factors or not?
I think it would be inconsistent with the any other necessary, so it couldn't be exclusive if we're doing any other necessary. But I don't have a recollection of exclusive at all. It just doesn't seem to be consistent.
Any other thoughts? I didn't feel it was necessary. I just found it in other parts of my stuff. So I just wanted to make sure I hadn't made a mistake, that was something that was supposed to be in there. Let's drop down to G, the edit to change the relative income we had of both households. Now, that is the language we had. The only reason I have of the obligees as a potential edit with the H edit is based on the public comment we received, I believe it was last meeting, about the concern of the impact on an obligor versus an obligee. Now, the language we've agreed to as a committee is just the relative income of both households. The concern from the public comment, I felt, would be resolved by this edit if it was something this committee wanted to entertain.
Madam Chair, Keith Pickard for the record. I think that if it's both, then that includes the obligee's household. I think that this narrows it more than I feel comfortable. I think both is more appropriate.
So the concern would be, and my concern would be, from knowing how different judges and courts have dealt with, well, the spectrum, I should say, of how courts have dealt with the household income of the obligor. So my spouse, who's a new spouse, who doesn't have a duty of child support to my child from my prior marriage? Is it a dollar for dollar of that spouse's income? Is it a 50% because that's community property interest in it? Is it added dollar for dollar? Or is it that we're really looking at the fact that you have less living expenses as a result of contribution by an adult cohabitant in your home? But I don't know that it's necessary. I don't know that I believe in the language I have necessarily here, and that may sound strange. I didn't want us to neglect a conversation of the concern expressed by somebody in public comment that I didn't think was something to just throw out with the garbage. I think it was something to take a look at. Any additional thoughts on it?
I agree with Assemblyman Pickard. I think both would include the obligee, but including obligee would negate the court's ability to consider the relative income of the obligor's household, which may be an individual paying child support that is now no longer working because their spouse is working, and I think those are circumstances where if it's just said obligee, I would not be able to consider that as an adjustment factor.
So no agreement on these edits. Leave it at the relative income of the the relative income of both households. Ms. Baker?
That would be my preference.
And I think where I see the confusion coming up is when we're looking at households, I think we're usually considering more than two adults living in a home that are not just roommates. We're looking at spouses or domestic partners or just live-in partners. And I think the question is, do we then take into account if I'm renting a room or if somebody's coming in and they're contributing, they're staying in my house and they're contributing to other expenses, does that constitute household expense? Are they part of the household in terms of those expenses? Frankly, I've been having some problems with trying to figure out how to use this adjustment factor, when to use it, how to use it. I find it very confusing. To me, it's clear if there are two situations where I've been able to understand it. One is the one that Judge Hoskin just talked about, where I'm now remarried and I don't have to work anymore, and I have joint physical custody. And so let's take a look at, how do we offset my income? And then the other one that I really see it in is if I'm making $6,000 and the non-custodial parent is making $2,000, do we look at the relative income in terms of adjusting the non-custodial parent's income? But then I have some difficulty about how this gets applied, and I see the same issue coming up in my courtroom. How do we apply this? When is it properly applied? And I don't know whether that's judicial education, but I find it a confusing adjustment factor, and I think, frankly, that if I find it confusing, so is the general public.
I think from private cases perspective, the injustice that was complained about in the public comment is something that isn't a uncommon complaint. We do have the word relative in here. We do hope that a judge is reasonable about it and isn't saying we're going to calculate your child support based on your combined income of that household. I didn't think it was a horrible element for it to be really, it's about the contributions to the living expenses versus you have somebody in the home, they're in your household, and they aren't contributing to living expenses. So it really isn't a benefit to you. I mean, it can be roommates, right? The way we've got this, the relative income of both households is add up the income. My concern is the abuse there. And my other concern is obviously judges doing anything from, okay, we'll do 50%, others saying add it all in. Oh, I'm going to give you, okay, we'll swing your child support by $30 based on that. I do think it's one of the gray areas of complaints. I do think I do know it was one of the initial complaints that started us on the road to ever getting to a commission being made at the legislature. This was several sessions ago, where it was an issue from the Obligor's perspective of I'm making $2,000 a month. I'm the obligor. The obligee is not making any income, and she's living in a multi-million-dollar home because her new spouse is extremely rich, and I'm paying this huge child support amount. So I know it's a common Nevada complaint. I know we hear it a lot, and it's not, and I know that's part of the reason we have the factor in here. I worry about I worry about the vagueness, and maybe this is one of those back burner things that's just dealt with in the future by this commission as to whether or not it's has additional tweaks. And if we're good
Madam
with
Chair,
the
if I
prior
may.
language, then we're good with the prior language. Yes, sir.
Sorry. If I recall, that was Assemblyman Ellison's bill in 2017.
Yes, sir.
And that was very contentious. But it is absolutely a complaint, and I think it comes up every year. So I would hope that we can deal with that here, and I do believe that adjusting it from the existing deviation factor, L, the relative income of both parents, to the relative income of both parents' household or both households, will tend to resolve that. I do think it's a perennial problem, and I would hope that we are bold enough to address that here.
Well, whether we address it by July 1st or we continue to address it, I know, and no offense, Judge Hoskin, but I know the flavor of the judges is to have that broad, just relative income of both households. I do stress about the abuses, and I do know of the complaints, as Assemblyman Pickard just noted, that led to the creation of this commission. And I know that was one of the bases. That was one of the very specific bases.
And that was ultimately what I was just trying to bring out, was that this is the issue, but I do believe the broader language is going to allow the courts to do justice more often, because if we limited it just to obligees, then half of the problem isn't addressed. And I'm going to, encourage everyone to adopt both.
Okay. Unless there's a motion to change to the language I had here, it'll remain at the prior language. The stars that are on that page for the Wisconsin language is not an edit. I just found it interesting when I was dealing with this issue of the public assistance stuff, the way it was defined in the Wisconsin language, very detailed, minus my typos in there I'm now noticing. But thought it was good information just to share with the committee in case we did want to make any edits to our language, I guess. It's not a suggested edit at all. I just wanted to pull that. I saw it, I pulled it out, I threw it in here just so that everybody could see the way it was written in Wisconsin. Now, under incarceration, I highlighted set to no less than the minimum child support allowed by law because of our vote on minimum, to not have the minimum specified in our statutes. We have this language in the incarceration language that's now in conflict that we need to resolve. Thoughts from the committee on this? And Ms. Baker, I know you also had another concern within the incarceration language.
Do you want to
that
deal
are
with one
currently-
at a time?
Yeah, let's deal with it one at a time. Sorry, I just wanted to not foreclose on that. Thoughts? Because obviously we have to edit that.
I'm sorry, edit which?
Sorry. Under incarceration on page 8, section 1, subsection B, we have defined suspend. And we have suspend means that the payment due on the current child support order, an arrears payment on a pre-existing arrears balance, or interest on arrears created during a qualifying period of incarceration pursuant to this section is, by operational law, set to no less than the minimum child support allowed by law. And we don't have a minimum any longer. And Mr. Sanford brought up this concern, which is the reason I
Functionally, we
highlighted
do.
it. Do what?
I'm sorry. Functionally, we do, in that the low-income table sets it at that first upper left quadrant.
With the ability for the court to adjust it to a smaller amount than that. Meaning court could adjust it to 0 based on our votes, which is what we agreed on when we set that. But when we agreed on the language in the incarceration language, we were comfortable with it because we knew we believed we were going to set a minimum amount.
Is that, even if we go there, is that suspending or is that still modifying? If we're not going to 0, is it really suspending?
The modification.
I'm just thinking that we may need to change the definition if we're agreeing not to go to 0.
I know we were all, especially with the public comment we had received, we all got to a place where we got a little uneasy with an absolute 0 in incarceration. Or I believe, that's my feeling about the committee, that we were uncomfortable with saying you go to jail and it's just going to be a 0 child support. And we had a lot of discussion about the fact that, well, if it's at least doesn't go below the minimum, and of course at the time our minimum was still at 100, or in theory it was. We hadn't said it, we hadn't discussed, gone back to it, but we can't ignore the way this language is when we don't have set out specifically in the statutes an actual minimum. Especially if it's going to be by operation of law, right? We've got to be specific on that. Mr. Sanford had brought up this concern, and so I didn't let it go away. And because I agree, it's, especially when I went back to our minutes to assess how we got there with the whole concept of there would still be a child support amount. So.
I hate to bring this up, but do I recall correctly that the federal guidelines require it to go to 0 on incarceration, or what's the intersection there?
They don't require it to go to 0. Hold on, we're all digging out those CFR language on incarceration. Actually, I think it's in the final rule. Let me look at the final rule.
I think the requirement is to modify it or advise the parties of the right to modification, but I don't think they require it being 0, although that's their preference.
And I like that, because I think that, in my view, it should be rare that it goes automatically to 0, because most of the time, arguably all of the time, someone is incarcerated, it's for voluntary acts, and it shouldn't alleviate their obligation to their children.
I'm looking in the final rule at page 93537, which deals with incarceration. And it says that they agree that incarceration is a factor in determining a substantial change in circumstance. So they revised 303.8C to indicate that such reasonable quantitative standard must not exclude incarceration as a basis for determining whether an inconsistency between the existing child support order amount and the amount of support determined as the result of review is adequate grounds for petitioning for adjustment. So I think that they contemplate that there's going to actually be a review of the existing child support amount to determine whether it is appropriate to adjust based on incarceration.
This is Karen from the DA's office. I'll renew what my statements were when we first discussed this, and that is that I believe child support should be based upon actual earnings. And if an individual is not earning any money, child support should be set accordingly, or at least judges and hearing masters should have the discretion to set it below the statutory minimum. So I don't particularly care for language that says that in any statutory scheme that says, that gives that power, or essentially takes that power away from the judges to say, we cannot go less than the statutory minimum. I like the idea that judges and hearing masters can make findings of fact that go below that if necessary. So my request would be to remove that. A secondary issue is the suspend language. Right now, the state of Nevada in the 4D program does reduce orders to zero. It would cause an interesting situation if our judges were not permitted to do so. The other issue is the springing language, which we have recent case law that doesn't really favor that by the Nevada Supreme Court. So when we look at the wording of suspend, that could be a good thing for us. But then is it really a modification, or are we modifying it to this new amount with the ability to reinstate it? And if we do have an ability to reinstate it because we've simply suspended the order, are we then reinstating it at that old amount, which actually could be very inappropriate? And that was the Nevada Supreme Court's concern when they talked about springing language. Or are we modifying it to a new amount, but allowing the order to then resume or activate a month after release at a new amount, perhaps our lowest amount? So I think we have multiple issues that we have to kind of look at when we're looking at this statute, because the suspend conflicts with the modification. So.
Well, and I would point out, this Kathleen Baker, that our support guidelines have to provide that a child support order be based on the non-custodial parent's earnings, income, and other evidence of ability to pay. So I think that that's problematic both from a suspension standpoint, because when they're released, we have no idea what their ability to pay is going to be. We don't know if they're going to get a job as soon as they're released, so we have no idea what their earning ability or ability to pay is going to be at that point in time. So I think that the springing forward is a problem, and that's what I was going to bring up with respect to this particular wording, and that's Section 3, when it talks about the obligation resuming on the first day of the first full month. I don't think that is going to comply with the feds.
But I do want to caution, if we don't have suspend or any type of springing language, we will have an influx of modifications, an incredible influx of modifications. So we need to try to find a way to sort of balance all of these various interests. And my position is we permit suspension or springing language.
Okay, it would be, it's my thought that kind of like the directives we've had before on specific homework for everybody to do would be to take a hard look at shared parenting paragraph and a hard look at the incarceration language for the next meeting. And take a look at our prior meeting minutes also, or of course, we've got the hearings, the recordings too. What did I say? Shared, sorry, split parenting. So split parenting, gosh, those terms are going to kill me. Split parenting paragraph and the incarceration language, and study the daylights out of it for the next meeting to determine what we need to do with it. We don't think we have any issues in the emancipation language unless somebody has a typo that, or other changes they want to make right now. I don't think so. Do we have consensus on that thought? I don't know that we are prepared at the moment. I think everybody's a little caught off guard on the incarceration language. Need to take a good look at it and study it. If you have proposed language that you want the committee to take a look at, please get it to me so that I can get it distributed to everybody to take a look at it. And same thing with the custody language. Please feel free to provide sample language to me for the committee to take a look at. All right.
Madam Chair,
Yes.
just a question as to the logistics. We have, as I'm looking at my calendar, one more meeting before
Okay,
the
well,
end of the
that's
month.
still part of our agenda to talk about. I'm going to cut you off for a second
Sure.
because I want to give you an opportunity to go
Well,
back to your
right.
concern under
No,
gross
I
monthly
just
income.
want to, with respect to what you were just saying, though, are you saying that you want proposals for language for action in the next one, or for discussion, or where do you see us going with that?
Similar to what I did here. Threw out some shared custody language. We all reviewed it, and we can take action on it. So yes, for action on those topics. What I think we're down to right now is fixing the incarceration language, dealing with creating a paragraph for split custody, or editing what's here for split custody. If you want to propose something on your issue you raised for the gross monthly income on the draw of that account language, Mr. Pickard, we will still be dealing with this as the master document right now. Those are the issues. As far as future agenda items, what meetings do we have scheduled? Joy? June 28th. That may be all we have scheduled. And then July.
That's all I have, and I will not be here for the balance of the month of June.
For the balance of the month of June. Then
That's correct.
you can still get language to us to be distributed and put on the agenda, and we'll discuss it without you. But it is 3:45. We still have some time, so I'll give you a few minutes here if you want to discuss that issue under gross monthly income that I cut you off on to do the other edits. Mr. Pickard.
Thank you, Madam Chair. I just, it was just something that had come up. It was brought to my attention that a party was taking draws on an investment account. They weren't, it wasn't restricted to the interest income. They were pretty substantial draws, and with the expectation that it would be ultimately consumed. And so the question came up as to whether or not that full amount, because if we recall, as we define gross income, interest on investments is included, and rightfully should be. But the court had chosen to take what the average draw was, not the interest earned, as a demonstration of income. And to me, that doesn't make sense. It's just like a personal injury award, which grows on its own. That's not, the compensation paid under a personal injury award isn't income. And so when we're talking about the corpus or the principle of any investment account, my question was ultimately, is the statement that income from interest and investment income under number 2 is to include the principle of that investment account, and I don't believe it does. And so my thought was to be clear, maybe on number 2 we say interest and investment income not including the principal, or we add under I draws on separate property separate property accounts not including interest. To make it clear that if somebody has separate property but for the interest that they earn and they're simply moving it from one account to the next, that's not income.
I disagree completely with you. If it looks like income and is being used as income and regularly received, it should be what the basis is, and probably it comes under an imputation of income because they're using that in lieu of an income.
Okay, but that's a different issue, and I think it's appropriate to impute income if someone is not working and they're merely living on their savings. You absolutely impute income, but that's a different affirmative step. The mere draw of one account, I mean, it's the same thing as moving money from a savings account to a checking account. It's not income. It's merely moving it from one account to another in order to handle it differently. It's not income. And so we have the ability to impute income. And I guess I would ask the courts to actually do that. But if it's money in an account and they're moving it from one account to another account, that is not income.
This is Karen from the D's. Just a sort of separate issue to all of you, various family court, family law practitioners. My concern is when you remove certain elements of income, non-income, however we wish to classify it. And I understand Assemblyman Pickard's analysis that we could use it as an imputation. My concern is if we narrow the scope of what's considered income, will that affect any type of quadros, wage withholdings, any sort of recovery to collect that monthly? I, of course, don't really engage in too many quadros, wage withholdings, but I would need more time to review the wage withholding statutes. But that would be just sort of a secondary concern if we narrow the scope of income.
I'll just weigh in here quick. I don't think that what Assemblyman Pickard is trying to accomplish needs a change. And he said it in his definition, what's income and what's not income. And under 2, it's interest and investment income. And certainly moving money from one account to another would not be considered income, but taking a regular draw off of an investment account would be considered income, even under the law as it currently exists. We have under 4 income from a pension retirement plan. I'm certainly not going to calculate child support on the entirety of a retirement plan, but only the draws that are coming out of it. So I think logic would keep us where we need to be without further modification of the definition of gross monthly income.
Well, and I would toss out there that obviously our prior statutes did not have this well-defined or this extent of a definition for gross monthly income. So this is leaps and bounds closer than we have been before in giving real good guidance on what income is. I would hope, like Judge Hoskins stated, that our judges come to the same conclusion because, that may be a cursed word by saying hope, right? But
I'm sorry. And Madam Chair, I don't want to sound like I'm asking for a change. This was just something that came up over the past week, and it gave me some pause So I don't want to take any significant time on this. I just wanted to bring it up. It sounds like there's no appetite to go that deep into it, so it's not a problem for me.
Okay, any additional comments on that? Okay, going back to future agenda items, I kind of laid out the issues I see. Does anybody have anything additional they want to add to that? And it's June 28th is the next meeting, so, and that is really a critical meeting, that on those two issues that everybody's done some homework to really dig into it. And I'm going to recognize our Senior Deputy Attorney General who's come up to the podium to make a comment on this agenda item.
Thank you, Senior Deputy Attorney General Amy Crow. For the record, the deadline for obtaining an R number for permanent regulation will be close of business Friday, June 29th. Now, that is only a draft, and certainly LCB is going to make markups, but we will need to provide them something on Friday, June 29th.
Okay, so based on votes that we make at the June 28th meeting, I will, as chair, need to make those immediate. We'll have to be very specific on the edits, not vague, not send us away to work on the language or anything. We're going to have to be very specific on June 28th so that I can get it to the Attorney General's office to have it submitted for the R number. Also, just for public consumption, know that DWSS will also give notice of a public workshop once this comes out of, it'll come out of LCB. There'll be 30 days notice for the public workshop, correct? I'm looking at Amy Crow again for advice on this. So I believe it's 30 days notice, but.
I'm going to have to look
Okay.
again. But the workshop can be held while it's still in LCB review.
Okay.
But if we make changes, we'll have to make that available to LCB.
Okay. So note, commission members, you have the opportunity to attend that public workshop. It is not a function of this commission. It's a function of DWSS following its requirements for administrative codes. But it's advisable for us to be there so that we can participate with the public in that workshop and any assistance that can be given by this commission. Not mandatory, though. Just something I advise as chair. Any other comments or questions about how that future agenda will work on June 28th? We do have the July dates. Whether or not we need the July dates, I guess, will be dependent on any confusion that comes out of LCB on the directive we've given them or not given them. The Assemblyman Pickard, I had your email here somewhere. Assemblyman Pickard did go to LCB for a little more clarification because we had kind of talked to them, we had asked him to talk to them about, legislative intent, notes, comments, declarations. The response from LCB is that, is the following, and I'm going to read it, and that's kind of boring, but I want it very clear what we can and cannot do. There are examples of legislative declarations, quote, or parentheses of intent, in parentheses, in NRS. We can either codify them and give them an NRS number or codify them as a reviser's note to the statutes. Now, mind you that we are going to be in the administrative code. We will not be in the NRSs. And that was per the legislature. We had public comment on that. And sir, I'd like you to know that that was legislatively decided, and this commission does not have control over that at this point. We can't control it going back to the NRSs. However, the preference is not to draft legislative declarations because they can be broad statements that may be either over-inclusive or under-inclusive of the statute as a whole. I think LCB's preference is to allow us to draft the initial substantive provision in a manner that is clear, concise, and a true expression of what the legislature is trying to do. We believe that the statutory substantive provision should stand on its own. Throughout history, those clauses have frequently essentially conflicting statements with the substantive provision that the declaration is intended to clarify. This can be the result of many different situations. For example, later amendments to one section and not the other, or agreements in order to ensure a bill's final passage. Raise the reasons why the legal division prefers not to include them in the bills. That being said, you will see examples of statements of intent, legislative declarations, and preambles in both NRS and the statutes of Nevada, so it is not prohibited. If one is included, it may be better to include as a transitory provision that will be codified as reviser's notes, so that future amendments to that section being added/clarified by the statement of intent will not also require an amendment to the statement of intent. Another option is to add more clarifying information to the Legislative Council's digest to a bill. The digest explains the legal effect of the bill. Of course, we're not dealing with a bill, we're dealing with a NAC. So I say that in terms of for our next meeting on the 28th, for everybody to take a look at some of our notes that we have in our master document and keep that in mind as to whether or not we want to convert those into actual provisions in our suggested statutes, or leave them as just notes for LCB to consider, or how we want to deal with them. But please, if we can avoid the notes and convert them, it might be advisable for us. Okay. We good on that agenda item now? Meaning the discussion and approval of ideas for future agenda items. Any other comments on that? Yes, Mr. Sanford.
This is Joe Sanford. I guess going back to that purpose, I know that at least one of the possible comments we had considered adding was an example of the formula calculation and how it worked. I guess based off that email, it sounded like they didn't want that. And since I haven't created it yet, I guess I would ask if the committee has any desire to have that for the June 28th meeting, or just let LCB do what they're going to do.
My opinion would be don't create it. Other comments, thoughts? Anybody else?
I don't have a comment on that, but I do have another comment.
Well, let's answer
that what you're
Mr.
asking
Sanford
about?
first.
No, well, that's why I say I didn't know if that's what you were saying. It was vague, but
I don't think that it benefits us to give LCB an example. I think we made some changes to the language that I'm satisfied. It's much more clear. Obviously, education materials in the future will need those examples probably. Okay, Mr. Judge Hoskin, not Mr., sorry.
yeah, that's fine. This is my one more plug for an effort by this committee to indicate that the changes that we're making to the child support are prospective in nature and not an invitation for everybody with a child support order to run to the court. My suggestion would be that we put something in there that they deal with child support orders that have been issued or modified after a certain date, as we've done in statute previously. But I think both the courts and the 4D program's part of a court are going to be inundated because of the substantial changes we're making if we don't include some language to indicate that there needs to be a review. It needs to be issued or modified before this will apply to every child support order. So if we could put that on the agenda.
So the discussion, that we had in the past for the master document was whether or not that would be considered additional modification language within our authority or not. I'll tell you, there is specific language. good old Wisconsin. They do have their language is a modification of any provision in this chapter shall not in and of itself be considered a substantial change in circumstances sufficient to justify a revision of a judgment or order. We'll just put it at everybody. I'll make sure it's on the agenda for the 28th, that specific issue and that specific language, or whether or not we can modify it in a way that it falls within our authority.
Thank you.
Madam Chair, this is Bridget
Yes.
Robb. And first, I want to preface this comment or this request by saying I think that staff has done a remarkable job with some of the very quick turnaround of minutes and that kind of thing. But given the fact that we are going to need to be on point for our next meeting, could we have these minutes at least a week or even 10 days ahead of time?
Yes, Joy is shaking her head yes. She has been wonderful to us, but our staff is agreeing that they will get on these minutes immediately and get them to us as soon as possible.
Joy, thank you very, very much.
Okay, additional comments on this agenda item? All right. Close agenda item number 9 and move to public comment. Is there any?
Madam Chair?
Yes.
Before we go there, I just want to say thank you to the committee, since I won't be here for the last meeting, and I don't believe I'll be available on the phone. I just wanted to say thank you for everyone and their hard work. This has been really hard work, but enjoyable, so I appreciate the efforts of everyone involved.
Thank you, Assemblyman. Okay. Public comment. Is there anybody in Las Vegas that would like to give public comment?
There are none.
Okay, thank you. Anybody on the phone that would like to give public comment? Hearing none. Anybody in Carson City that would like to give public comment? Seeing none. Agenda item number 10 is closed. I would take a motion for adjournment. Anybody? Come on.
Move to adjourn.
So moved.
All right. Assemblyman Pickard is the second. Kathleen Baker the first. All in favor, state aye.
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 All right.
Aye.
Opposed, state nay. All right. Thank you. We're adjourned.